Welcome to another casual, unscripted conversation. Today we have a special guest with us, Tom Nevin, who is starting a company in Australia called Loquitur, which is a witness familiarization company. Tom, welcome to this conversation.
Horace, hello. Great to see you. How are you?
Hello. Doing very well. We're going to jump into a few questions because I know so little about litigation and so little about dispute resolution that you're going to have to guide me through a lot of what we're talking about today.
My pleasure, mate. Let's jump right in, hey?
So the blog is about two topics. The blog is about, if you think of it as like a Venn diagram, one circle is what does technology do? In any context, what does technology do? And the second part of the Venn diagram is how do lawyers become better lawyers? And I thought with Loquitur, what would be really cool is we kind of talk about, well, what's the objective here? How do we help litigation lawyers be better litigation lawyers? And then maybe then we can bring in a tech angle of, well, what are the sorts of possible things that we can do? But fundamentally, it's about, well, making your lawyers look good, winning cases.
Yeah, I suppose it is at its at its barest bones. We're there to help lawyers get better results for their clients, and I suppose more directly, we help their clients and in particular the witnesses that are going to give evidence in a way such that they're able to deliver their evidence more effectively in court. And thus, perhaps for lawyers to win more cases in court or various other forums, as they may be, arbitrations, investigations, and so on and so forth. But I suppose, leaving aside the benefits for clients and lawyers, in that regard, I suppose there's probably a more benevolent, overreaching purpose for this whole thing, which is to, have the courts get better evidence. Because the person who's giving the evidence will hopefully be less flustered and less scared and less nervous as a result of having been even more thoroughly prepared for the very stressful, very taxing, very difficult process of giving evidence under cross-examination. And that's kind of what one of the big benefits, which I don't think is perhaps it's overlooked by a lot of people in the commercial side of things. There's a much greater benefit. And I think also there's a big benefit to society in that it does demystify the law in a way. It democratizes it. People understand a bit more what goes on in court. And it just provides that little bit more openness to people and to the public. And then I suppose also with that, people trust the system more, trust in the judiciary, and so on and so forth. So that's rather a long way of saying that we try and help lawyers win cases, but we do various other things in relation to that. And it all, I think, stems back to we help people, help witnesses deliver their evidence more effectively in court.
That is a really cool way of framing it. And I love the kind of public good angle because it's not something that is talked about very often. I think a lot of times lawyers think it, but they don't necessarily put at the forefront of going, well, this is my mission statement. This is what we're trying to achieve. And so I think that's super cool. What sort of prep work do you do for witnesses to help them overcome this anxiety and fear?
Aquatur is an independent third-party training organization, and we provide what's called witness familiarization. So this complements the prep that the legal team will do up in advance of the hearing. The legal team does everything in relation to the evidence itself. We help the evidence delivery. And what we basically do is we have one of our barrister trainers. So we get a barrister to go in, sits down one-on-one with the witness and goes briefly through that. This is what's going to happen in the court and so on and so forth. But we then go through in quite a lot of detail over the course of several hours what types of questions and that cross-examiners ask generally to try and sort of get where they want to go? What's their strategy? What's their tactic? How do they do it? What traps do they set for people who are being cross-examined? Do they sort of ask a series of questions where you say yes, and you say yes, and you say yes, and you say yes? Then they ask a question to which you say yes without really thinking about it. Whereas if you'd stopped and thought about that answer, you might have said, well, no. So it takes, that's just one example, but it takes you sort of through the black arts of cross-examination by barristers and explains to people, what they're doing, how they do it. Obviously, all in a general sense. We don't know anything about the evidence. The barrister is independent. We're independent. But then the barrister will explain how to recognise, firstly, that is happening. And then I think, most importantly, secondly, how to actually answer those questions in such a way. So say a barrister will often ask a closed question, which is based on a premise. And by responding to that, you inevitably accept the premise on which it is based.
Yep.
So, we teach witnesses to recognise when a closed question is asked of them, which most of the time it will be, and then to counter the premise on which it's based before giving your actual response. And so you might say, well, that's actually not quite correct. This is actually the case. So you're not accepting the premise, you're sort of explaining what your actual evidence is, or you're explaining what the actual situation was. And without being sort of herded in the way that the barrister wants you to go. So there's that. That's very important, that practical element. Well, so the theoretical element is very important. And then what we do, which is quite important and very, I think, necessary a lot of the time, is it's the practical application of those things that we teach in the sort of theoretical part of the course. Is the witness is given a mock set of facts, generic, general set of facts, unrelated to the underlying case, and they're given a mock cross-examination by that barrister on that set of facts. And they can choose to be this witness or that witness, and they give their evidence according to a set of facts that they're given and read in advance, and they're cross-examined. And in doing that, they'll be asked questions. They'll be asked, the barrister will try to lead them down that sort of merry little path, and they then have to try and implement those strategies that we've previously said to try and give their evidence rather than be taken in that direction. And it could be little things like, pause and take a breath before you respond to any question. And we teach that in the course. We say, before you answer any question, pause and take a breath. And that stops the barrister from getting into a routine and asking the questions and having a quick back and forth. By pausing and having a breath, you give yourself an extra second. So little things like that. And then obviously there's a lot more things. And then, the mock cross-examination might go for 20 minutes. And then that's videotaped. At the time, there's an iPad in the room. And then they watch it back. And the barrister says, see here, that was really good. You paused, took a breath, and then responded. Here, you got flustered. When you get flustered, what you should do is pause, take a breath, refer to your statement if they've asked you about your statement, so on and so forth. I've set a trap for you here. You saw my trap, and you responded sensibly to it, or you didn't see my trap, and I trapped you. And then you'll repeat that process a couple of times on the facts, the mock facts as they are, and that practicality, that practicing of the strategies is quite beneficial to the witnesses. And I think that's basically how we try and help witnesses get better evidence by putting them through a bit of stress now, such that the actual cross-examination, while it will be stressful, they know what to expect, and they're armed with some tools and some tricks of their own to actually go in there and make it slightly more level playing field, so to speak.
Tom, you mentioned the dark arts, of the black arts of litigation, and I haven't heard it called that before. I don't know if it's like common parlance amongst litigators, and so much of what lawyers do is this kind of unspoken, implicit set of skills, right? These soft skills that lawyers learn from a lot of experience. How do you teach that to someone? How do lawyers get better at that? And therefore, how do you counteract that by teaching these witnesses those exact sort of behaviors? Like, I imagine it's quite difficult to first gain that implicit knowledge, and then second, teach someone to counter that implicit knowledge.
I mean, a lot of our barristers, we choose them very carefully. Firstly, they're actually personable and they're people persons, so to speak. So they're quite good with people. They can relate to clients. They're a bit hands-on. They're willing to sort of like explain things a couple of times to a client if they're nervous or whatever else. Or sometimes, to be fair, you get really, the witness is a bit arrogant. They don't really care. They're not really paying attention. And you have to break them down a couple of times to build them back up. But a lot of our barristers, and we have taught the advocacy course and teach the advocacy course in various universities, as well as having a commercial or whatever it is, practice itself. So they're used to teaching those tricks to people who want to become barristers or lawyers, I suppose, more generally. And they then also have to teach it to witnesses. And I suppose that's just part of the art of being a good teacher, is being able to teach it not to someone necessarily who wants to specialize in it, but someone who has been has come at it from a totally different way and is not, I won't say they're not dragged there, but they aren't there necessarily relishing the thought of being there. As to how the barristers do it, that's just a skill that a good teacher will have. I think using examples, using a few war stories is always important. Relating to them. There was this one time when I was cross-examining someone and I said this and I said that and I said that. And then by using that personal example, I think that that allows the witness to relate to that and perhaps think, well, that's something that I probably would do. I won't do that one, and so on and so forth. So I think there's a few things that they do. I'm not a barrister, and unfortunately, I'm not. I'm not as well versed in the dark arts as they are. But yeah, look, they've got a box of tricks, and they use it. And I suppose in a way, we're opening that box of tricks up a bit and putting a bit more of a lay down there to help the other people, to help the witnesses, just give their evidence in a slightly better way.
So 5-year plan, what do you think, what would you like to happen within 5 years?
I think the first thing that has to happen is the acceptance of witness familiarization in Australia. And that will take time. Hopefully it'll take less than 5 years. I expect it will take a lot less than 5 years. I mean, people are generally open to the idea, made so by the fact that it exists in the UK, I think is very important. But they also see it as a valuable tool and a lot of use and a lot of benefit coming out of it. So firstly, I think, becoming a commonplace accepted practice. And I think that's probably the main thing. And then I expect there may well be, and this is perhaps more on the expert side of things rather than on the lay side of things, perhaps a more formalized or standardized method or methodology of teaching witnesses, expert witnesses, how they can give better evidence, and perhaps including that as part of their CPDs and so on and so forth. I mean, it exists already, but it's a bit ad hoc. It's a bit, it's more ad hoc at the moment, and it's not done in such a sort of there's no sort of global certification. I don't necessarily think that global certification is a good idea, because inevitably there'll be witnesses, expert witnesses, who come in to give evidence who aren't necessarily going to be certified, because they might only give evidence once in a blue moon on a very, very niche point. But I think that the expert field will probably go that way, and there'll be degrees of certification. And that maybe is a bit more than 5 years, but it's certainly something that I see happening. And we're looking to get involved in that as well, in due course. The hurdle that I have to overcome, and I think that it's a hurdle that a lot of people have to overcome, is when you're introducing a genuinely new concept.
Yes.
You do get a bit of, and you know it yourself, I mean, you get a bit of skepticism, not a lot, but a bit of skepticism, a bit of, what is that? And it's just that changing people's mindsets. And that, tech can certainly help in that by, making it more accessible, and, put a video up online, for example, and that sort of, this actually, A, it's not bad, but B, it's actually quite good. And that sort of getting it out there, I suppose, is quite helpful. But it's just that sort of change in the mindset of bringing in innovation, a very new innovation into a new market, especially one as a bit conservative, we'll say, as the legal market as well.
You're very generous in describing it as a conservative market. I think the transformation journey for any lawyer is tough, because they've been doing the same thing, especially the more experienced and older lawyers. They've been doing the same thing over and over again for however many decades.
At least if you do get the sort of the skepticism, at least you know you're onto a novel and innovative concept, I suppose. So that's the silver lining to it.
I love your optimism, and I think that's right. Like when people go, I don't get it, that's when you know, aha, I've got something brand new and novel.
Exactly, yeah.
I love that the base of all of this is about giving better evidence so that courts have better information.
Well, in fact, one question I had for you, Horace, actually, was knowing a bit about Loquitur and the way that you see it operate and the benefits you see to it. How do you think that tech could help us?
Ooh, okay. This is a tough question, and thank you for the role reversal.
Sorry to put you on the spot.
I think people often ask the question, how does tech help? And I think the right question to ask is probably, what are the problems we're trying to solve, and then therefore can tech apply? And it's a slight different order in thinking about where tech fits. And from my, I would say, relatively superficial understanding of what you do and what Loquitur is aiming to achieve, the key objectives you want is for witnesses to give the best possible evidence, the clearest possible evidence that avoids confusion. And a lot of that comes down to human behavior. This requires people to have repetition, familiarity, and preparedness. And I think what tech is really good at doing is repeating things. It's good at repeating things to a single person over and over again. It's good at repeating things from one case to the next case, so that training that was given in the past can be used as a sort of springboard for the next set of training to say, hey, look at how this person has done, and therefore be careful of that. I think the expertise that barristers have in giving these sorts of things and noticing the sorts of signals and warnings and pitfalls, that is something tech can enable. We're going to talk advanced tech for a minute. There's a lot of good work happening with facial recognition, with voice recognition, with the sorts of things that 10 years ago would be impossible for a computer to do. And these days, we can put a witness in front of a camera, and you can kind of see the emotions being highlighted on their facial expressions. And you can see when they're stressed. You can see from the tone of their voice, well, what might happen next. And these sorts of signals, and I'll send you a link to this sort of stuff afterwards.
Wow.
Yeah, that a computer vision can just read and go, "Ooh, there's your warning flag. Be careful of that." Allows you to have these sort of almost premonition into the future of what could happen. So that's like super advanced tech, but it's happening today. It's being used today to recognize emotions. So what you spoke about earlier of stress and anxiety, you can see it in the witness as it's occurring. You can see when they're getting flustered. So futuristic kind of projection. You can give a witness an Apple iWatch and record their reaction. And when they're getting stressed, maybe the Apple iWatch can buzz a little bit to remind them, take a pause. Just 2 seconds. Think about what you're doing. And I don't know if that's allowed from an ethical perspective.
Well, I mean, I think that may be getting a little bit
sci-fi.
Extreme. Yeah. Depending. I mean, also, obviously, it has to be done on very removed and hypothetical sets of facts. I mean, look, we could strap the poor witness into a polygraph test and watch the needle. That would make them extra nervous and put a bit of extra stress on them. And I think I heard some crazy psychological experiment where they had to sort of, if the polygraph test thought that they were lying, it would give them a small jolt of electricity to make them even more stressed and really put them through their paces. I think that might be going a little bit too far for what we do. But I mean, I think that certainly, perhaps something that you mentioned before about how, if you've educated someone, chances are other people can learn from that same sort of thing. And I mean, even just something as simple as videotaping one of these sessions and providing it as a training, as part of our training, to say, here, look, I've got the iPad here, whip it up. Here is an example of me doing a similar line of cross-examination with someone. And you can see what I'm doing with this person here. I'm doing X, I'm doing Y. Here you can see I'm leading them up the path. I'm setting the trap, they wait for it, bang, he's fallen into the trap.
Yep.
So on and so forth. Although having said that, by getting the videotape and watching it back through with the actual witness itself on the mock cross-examination, that has that same effect. And I think it's even more punchy and even hits home a lot harder because it is that individual there in the camera. And they can take it away and watch it if they really want to.
Well, it's what you've just said essentially points out a really important feature of technology, which is you don't need high tech to achieve a good result. You need the right technology applied at the right point in time. And a lot of legal tech or technology companies have a pitfall that they have to watch out for, which is don't build something as a solution looking for a problem. Find a problem first and then go, well, how do we solve it? What are the actions today? What can we improve about these actions? And so once you map out the user journey of, well, what do we do today for witnesses and how do we get them familiarized? Okay, now where are the points where we can really improve the efficiencies?
And I think with the video, and I mean, you make a good point. It's an older technology, just used in the right way.
Tom, I am going to say thank you so much for your time and for taking me through this kind of wondrous black arts of litigation and what witnesses have to do when they go to court, because I know nothing about that.
Absolute pleasure. Great to chat to you about this. And indeed, it's a great pleasure to chat to you always. Hopefully, you'll never have to go to court. But if you ever do...
I'll ring you first.
Give me a call and we'll give you a very special grilling by one of our best barristers.
That does not sound like fun, but okay.